Greetings, welcome to thctrust.org. This video we're covering an administrative proceeding. We used to say administrative procedure, but I'm trying to get more in the habit of saying administrative proceeding. And we are going to cover this administrative proceeding whose focus is to establish on the record the fact that the bank never gave us a loan, they never intended to give us a loan, and that they made false representations and they misled us to influence us to convey an interest in our security instrument, which was securitized and used to fund the loan. Many of the things that we've studied through modern money mechanics, reading the banking statutes, understanding how money works, and knowing what has happened to substance-based money based off of all the national emergencies. All of these things that we once were not aware of, and our ignorance that once kept us in commercial slavery or debt, now that we become aware, we're taking all of these things that we've learned and we're compiling them in an administrative procedure, and we're dealing with the truth of the matter. We're trying to lay the axe to the roots, to the very foundation, and destroy and have evidence on the record that the bank didn't give us a loan, which will destroy the root foundation of any type of obligation or indebtedness, or destroy any presumption of an enforceable right to foreclose against your property. This is what the purpose of this administrative procedure is. Now, this video assumes that you already understand the purpose of doing a notary presentment. It presumes that you understand how to do a notary presentment, and if you do not understand how to do a notary presentment, how to use a certificate of service, the purpose of using a notary presentment, then I encourage you to visit www.thctrust.org, which is our website, and create a free account if you don't already have one. Log in, go to the right side of the website, and you'll find a menu that says Administrative Procedure. And in that menu, that will provide you the basic foundational information that you have to know about doing a notary presentment, what the purpose of a notary certificate of service is, why you need the notary certificate of service, the notary certificate of non-response, and the notice of default. When you do a notary presentment, your record pretty much becomes a judgment on the private side. And being that we can authenticate our judgments through the Secretary of State, which goes into the act of state, and them having to recognize the sovereign acts of another state. We're actually a different sovereign state when we're operating in trust on the private side. But I don't want to go too far off the course because we got to get into this administrative presentment. But the point I wanted to make is that this is an advanced video, and if you're dealing with a mortgage situation or you know that something is coming, I highly recommend you consider using this process but adding to it. If you don't know what a QWR is, you can look up a QWR. It's a qualified written request. It's a list of requisites that a servicer, I believe, yes, I believe it's a servicer. It may apply to the lender. It kind of escapes me right now. But check that out because it's important. It's important whether you send the QWR to the servicer or the lender. But nonetheless, the point I was making is this is a very bare bones administrative procedure. I basically set it up for you. I've done probably 80% of the legwork for you. I've prepared the notary certificates of service, the notary certificate of non-response, and I've prepared a foundational affidavit to establish those facts that I spoke about earlier, about the bank not giving you a loan, the bank using false representations and misleading you to influence you to convey a security interest in the land located at wherever your common address is, as well as the security instrument that was given value when you signed it. And I'm talking about the promissory note. So let's let's start by going. I'm going to start with the affidavit. Now, again, I want to remind you that I prepared this affidavit as a template. It is a very bare bones affidavit, but it has maybe some of the verbiage that you would consider in your own affidavit when you're establishing the truth of the record. So this affidavit is going to be part of an administrative process that is presented to your alleged lender as well as your alleged servicer to give them the opportunity to rebut or accept the statements herein as true. This is a part of the due process. Anyone who knows administrative procedure will know that. But I'm going to read through this. The undersigned affiant, Tex Lee Masson, hereinafter affiant, does solemnly swear, declare, and state as follows. The affiant's usage of the terms I, me, my, or us refers to the Tex Lee Masson, and I put trademark here. You could put trust, estate, or whatever. And this is kind of, I have to start doing these things as I become more aware and as I set the foreign side as trust up to properly operate in trust on the private side, if you will. I have to rethink about how I'm going to do these affidavits that are going to be used in the public. So I always say affiance usage, because remember, me as a man, the real me, if you will, for lack of a better term, is immune and exempt from commerce. So anything that I do in commerce has to be done through some type of vessel, which is basically a trust, which is not a living man. So now that I have to write an affidavit and swear under penalty of perjury, I'm letting them know that affiance usages of the terms I, me, my, or us refers to Tex Lee Masson trademark, trust, estate, or whatever. And that on February 4th, 2004, I entered into a transaction with Mortgage Investors Company, identified as mortgage contract number 123456789, a copy of which is enclosed herewith as Exhibit A. And in Exhibit A, you'll put a copy of the mortgage. You're basically stating the facts of what occurred. Mortgage Investors Company in this particular template is supposed to be like your lender, and you may even want to write in here, Mortgage Investors Corporation alleges to be a lender out of wherever they're from. Remember, this is just the bare bones template. I encourage you to add to it. By the way, the premium subscription members at thctrust.org do have access to this template. But again, it's very important that you modify it. And a lot of things that you see in red are places where you have to modify, but I didn't sanitize this whole document, so you have to really read through it. There's other things that you have to sanitize that's not highlighted. Okay, so let's continue to read through here. In the spirit of the contract, and I should say mortgage contract number whatever, and for equal consideration, I would mortgage, I missed something. The terms and conditions as represented to me by the representatives of Mortgage Investors Company is that I would receive a loan of money for $89,000, and that in the spirit of the contract and for equal consideration, I would mortgage a security interest in a security instrument for the value of $89,000, hereinafter referred to as the note, a copy of which is enclosed herewith as Exhibit B. I put a copy of your promissory note in there. As well as convey an interest in land located near 800, wherever, physical address is, to Mortgage Investors Company as secured creditor. On or about whatever date, Mortgage Electronic Registration System, MERS, executes an assignment instrument signed by Assistant Secretary DeWolf R. whoever, alleging to assign the mortgage contract number whatever to ABC Services Bank. And I would put C exhibit whatever in there, add another exhibit. ABC Services Bank represents itself to be a servicer of the mortgage contract. And that's where this exhibit A here, that really should be over here. And that's not exhibit A, that's exhibit C or whatever. So you see you got to edit through this. Most of the legwork is done. By the time you download this template, I would probably have already corrected all these things. Okay, let's see. On or about June 1st, 2013, affiant became aware that ABC Service Bank never gave a loan and that the transactions were funded solely by the securitization of the affiant's security instrument, and that Mortgage Investors Company did not lend the affiant money. ABC Services Bank used false representations intentionally, fraudulently, and deceptively to influence me to enter into a mortgage contract. The affiant, upon reliance on such false representation, pledged a security interest in a note in favor of mortgage investors' company. The affiant, upon reliance of the false representations made above, has labored over 4,000 hours approximately, and I made that into a money value. And the reason I chose to equivalent it into labor because that's energy that I spent, and that's a personal loss. I can only relate that to a monetary value, right? So I could have chose any value, but I chose roughly the same amount of value of funds that were paid on the principal, so to speak. Okay, so but anyway, I said I labored for 4,000 hours from February 2004 to February 2012 in satisfaction of the above fraud-based mortgage contract. I declare under penalty of perjury that the information above is true and correct, executed this whatever day of whatever. This is an affidavit, so the notary signs it. Okay. This is a private process, so I have to do a better job on this. But don't get wrapped up into this. If you don't really understand the private side and how to do all these little things, you're fine and dandy just doing it like this. You got to get something going, so you could do it like this. But what I was saying is, this is non-domestic without the U.S., so I have to reconsider how I'm going to do this affidavit. Let's just leave that at that so we don't get off the point. Okay. Here's your affidavit of truth, right? This is your most critical document. As you see, this is very short. The facts of record that you may want to establish as far as your mortgage may be a lot longer than this. So you can read through your queued up. I don't even say, I would keep this one short, right? This is the bulk of what this administrative procedure is. This affidavit of truth is the same affidavit that you're going to be presenting to the servicer as well as the lender to give them the opportunity to challenge or rebut the presumptions, because an unrebutted affidavit is presumed to be true. But the key is, a lot of people, and this is where a lot of us have erred, we always say an unrebutted affidavit is a fact on the record, but truth be told, an unrebutted affidavit still is hearsay. An unrebutted affidavit is the first part of the process of establishing that fact, and the second part is you have to have the certificate of non-response and a certificate of and the notice of default. When you have those certificates, or certifying the non-response and the default along with your affidavit of truth, then you have a fact, then you have a claim, and then you have that piece of so-called evidence that's an exception to the hearsay rule. So it's critical that the process is completed. This affidavit is the first part of it. So let's go back to the top here, now that we got the bulk of what our objective is with this administrative presentment. So administrative presentment, remember this cover letter is coming from the notary, because the notary has been appointed to witness the process. She's not involved in the process. She just witnesses the communications between the two parties so that everything can be certified. The notary is an officer of the court. That's why she has the seal. And if that officer renders a judgment, another officer can't overrule that judgment unless it goes through some type of proper hearing. That's why they always talk about being careful how you use your private documents, because when you adjudicate things in the private and you get a notary certificate on it establishing a fact for the record, when you complete your process, if you bring it into a court, it's almost as if you're bringing it in, just like when if a judge gives an order, you have to bring it into a higher court. You bring that same judgment to another court, and you're submitting it to the jurisdiction to potentially be overruled or whatever. So all that to say, be careful how you bring your administrative proceeding into the public, or how you bring your facts and your records into the public. So anyway, the notary presentment, this is a presentment of notice and claim under notary seal. Notice to agent is notice to principal. It comes from Sally Jones, the notary, to Tom Jackson in care of Mortgage Investors Company. Tom Jackson would be your CFO of the party of importance that you're sending this presentment to. It's regarding text meet Lee Masson, mortgage contract number, whatever. Okay. The service, all these things are important. USPS, registered mail. Why do we want to use registered mail? Because we're in the private and we're bonding our claim. We're holding individuals responsible. So you register mail it, restricted delivery. Look up restricted delivery, and I think they talk about it in the domestic mail manual. But look up restricted delivery. Whenever you send securities, you send them registered mail. Your affidavit is part of a security. But restricted delivery proves that only the recipient, Tom Jackson, can sign for that security, or his agent in writing. So this is a private process. Always use registered mail and a notary certificate of service. Okay, here we go. Notary says, Dear Mr. Jackson, I have been contacted by Tex Lee Masson, executor for Tex Lee Masson. And you know what? Here, when you get the right one, you're going to see this. It says, I have been contacted by Masson Tex Lee. We're using last name, first name, middle initial in your proper status. Executor for the Tex Lee Masson, which is the trust or the estate, from outside the United States for the purpose of presenting a claim under notary seal. I have been asked to mention that listen what the notary stating. She has been asked to mention that Mr. Jones, the CFO, may rebut the statements and claims in the presentments by executing a verified response point by point in the affidavit sworn under penalty of perjury to be received by the notary, to be received by the principal through my office no later than 30 days from this postmark to prevent issuance of a certificate verifying your non-response or default pursuant to my statutory authority, and that your response to the request regarding a statement of account is to be received by the principal through my office no later than 14 days from this postmark to prevent the issuance of a certificate verifying your non-response or default pursuant to my statutory authority. And that, most importantly, your failure to respond to the presentments shall constitute your consent and agreement with the statements, facts, and terms set forth therein. And all communications must be delivered through me at the above address by registered mail or certified mail to ensure delivery and appropriate certification within the time allowed to prevent the issuance of a certificate verifying your non-response or default pursuant to my statutory authority. Service in any other manner is defective on its face. Okay? Notice the notary says that they can use either registered or certified because they are in the public, so to speak. They're creating, remember, I'm not going to go into that. I was going to say they're using an in personam claim, kind of, sort of, but no, they can go certified mail from the public to the notary, and the notary can reach out to you because you're on the private side, right? When you contact the notary, it's registered mail, private to private, and they can bring it into the public, okay? So you're spanning jurisdictions. You, as the executor for the estate, under the common law side with your rights and exemptions, and then you have the public commercial side. And anyway, there you have it. The key thing is you're going to have access to all of these templates. Make sure if you edit this and you modify it, don't start adding a bunch of terms and conditions here because the notary is only a witness. They don't get involved in your process. Notice the notary. So when you do a notary presentment, you're going to have a notary that knows what they're doing because the notary is going to seal this document and send it off. You're not going to sign it. So there is your notary presentment. Notice in this, one other thing important. Notice in this notary presentment that we said, so the notary gave 30 days to respond to the affidavit. And it's not that the notary gave. It's typically, that's what it is. It's typically the 30 days and then, there may be another 30 days of another form of fault, and then another 90 days to make that supposedly. Let's not even go there because what I was about to talk about was a commercial affidavit, and this is not really a commercial affidavit at this point. It's just an affidavit to establish facts. There may be some commercial qualities to it, but it's not a lien. So I'm not going to say that it's an accounts receivable and all of that. Anyways, point I wanted to make is first we gave them 30 days and then we gave them 14 days to respond to the statement of account. Does anybody remember what the statement of account is? If not, let's look at it. Remember, we went to the affidavit of truth. We went through that. But something else in this same presentment package that we're going to present them with is statements of accounting under UCC Article 9, Section 210. What UCC Article 9, Section 210 talks about, it talks about two types of accounting. Accounting of unpaid obligations, that means how much money do I still owe you, and then accounting of collateral, and that's accounting of the assets that was used to secure the obligation. And according to UCC Article 9, Section 210, which is also codified in your state code, what you have to do is figure out what your state commercial code is and then look up statement of accounting or statement of unpaid obligations. But what it provides is that any secured creditor that's presented with such an inquiry from the debtor, that creditor has 14 days to either accept the statement that was presented to him by the debtor, in which the debtor believes is the total amount due. And if the creditor says that the statement is incorrect within 14 days, that creditor has to correct that statement. But the caveat is, in order to correct the statement, the creditor has to verify it, which means he has to swear under penalty of perjury to the corrections and to the accounting that he returns to the debtor. Out of all the time that I've been doing this, I've never seen an alleged creditor respond with the statement of accounting, just like they won't respond to the affidavit. A lot of people say, well, what if they respond? If your affidavit and your statements and what you're expressing is clear and concise enough, they will not respond, because there's so much fraud laden in the whole alleged loan, mortgage, separating the note from the contract, and there's so much fraud that no one is going to speak positively to try to defend what a bank has done. What they would rather do is try not to say anything, but to continue to collect, which is actually that's actually a kind of fraudulent practice within itself. You understand what I'm saying? But nonetheless, the point I'm making is they're not going to respond to these statements of account, and if they do, they will respond in such a way that is not acceptable. They will respond in such a way. How did the notary say it? Service in any other manner will be defective on his face. Well, she's talking about service, but the bottom line is, if they're not responding under penalty of perjury, it's an improper response. And if they do respond, with your competence, you'll know how you have to respond to what they're saying. You have to point out the defect in their response. And if that becomes too much for you and you get a response, perhaps you should consider donating for a coaching and consulting session with yours truly, Tex Masson, because I can definitely help you respond if somebody responds to your notary presentment. But again, in my experience, they're not going to respond. And let's read this letter real quick, because it is important. Now, before I go to this letter, let's look at the certificate of service. The certificate of service is what the notary is also going to include. She's going to include a courtesy copy in the envelope, but more importantly, it's going to have the notary seal on it. And your certificate of service is going to be the proof for yourself that the notary has witnessed the proceedings and she has presented all of these items to the other party for the other party to respond. What are those items? The affidavit of truth, we went through that, a request for accounting, and a notice of pending of rescission of signature. I didn't read that document. I'm about to read that document. But I wanted to show you all the things that you can do here. We sent them a statement of collateral that they have to respond to. We sent them a statement of account that they have to respond to. You could include a QWR in here. We didn't do that, but you could have just dropped one right on in there. A request for debt validation and notice of dispute. This doesn't have much to do with what we're talking about. This is a request for debt validation of the FDCPA, which is the beginning of a separate process within itself. But hey, since you're doing a notary presentment anyway, go ahead and throw that in there. Create more obligations and things that they have to respond to, right? And by registered mail, blah, blah, blah. So you can see how long this can get. This is 7 things. You could put 8, 9, 10. There's all kind of other affidavits that you can present in truth and require them to respond under penalty of perjury so that you can certify their default and establish facts for the records. Because in the next video, we're going to talk about how we can use this administrative record in support to file a quiet title action so we can rid ourselves of these threats to be foreclosed against and these mortgage issues and things of the such. We're going to talk about that, and the sole purpose of this administrative procedure is to allow you to certify all the records that you're going to need to support your quiet title action or any other lawsuit for that matter. As I said, all of these documents are already prepared for you if you're in the premium subscription group at thttrust.org. Let's read the this cover letter right here. Where is it at? Okay, the cover letter, right? So this is the other thing that's accompanying the affidavit. The cover letter comes from Masson Texley, executive for the estate of Texley Masson, goes to the office of the CFO of the mortgage investors company or the servicer and whoever else. And the subject is a request for accounting and a notice of pending rescission of signature from the mortgage deed. Remember, he gets the affidavit first saying that, hey, you never gave me a loan. This references that affidavit. Reference A, affidavit of truth. Reference B, mortgage contract number, whatever. Stamp copy from the county. Enclosure 1. This is something that you're enclosing with this. Request regarding list of collateral. That's under UCC Article 9, Section 210. Request regarding authentic statement of account. That's the second enclosure. That's also under Article 9, Section 210. Those are two different statements and burdens that they have to respond to under penalty of perjury that they will default to. And the letter explains it all. The purpose of this letter is to request an accounting of collateral and unpaid obligations regarding mortgage contract 1, 2, 3, 4, 5, 6, 7, 8, 9, and to give actual and constructive notice of the pending rescission of signature. The respondents are granted 14 days to respond to the affidavit under penalty of perjury with their objections, if any, before the claimant exercises the right to rescind the signature from the mortgage contract. The respondents may affirm their agreement and assent to the facts as set forth in the aforementioned affidavit and statements by remaining silent and opting not to rebut the claims within the 14 days allowed for the statements of account and the 30 days allowed to respond to the affidavit. Remember? 30 days for the affidavit. So I basically told him the same thing that the notary reminded him of. And here's your basic statements right here. We zero out the statement of collateral because it has become to our attention that they never gave us a loan. They couldn't have given us a loan. So they couldn't have pledged any collateral in support of securing a loan. No assets or collateral. And if they did, they can respond. And if they don't respond in 14 days, then this becomes the statement, the factual statement of the record. And the UCC even goes as far to say is even if they're no longer servicing this, they're still required to respond to this. But you got to get in there and read. Here's this other one, the statement of account. How much more do I owe you? These are also good if you do some type of discharge or whatever. Now, also, if you haven't done so, go back and just go to the website, thctrust.org, and click the menu that says mortgages and foreclosures, and there's another administrative proceeding that is already prepared for the Universal Residential Mortgage Satisfaction Act. You can combine it with this one. And here I have your certificate of non-response, non-performance, and I also have your notice of default, right? And then if you notice, after the notice of default, remember in my notice I gave them notice of the pending rescission of signature. If they didn't challenge anything that I was doing, then it construed their assent and consent to me exercising my right to rescind my signature from the mortgage deed. So after they default on that, this last template document here is the actual rescission of signature, where it says I-text Masson, the affiant, who is lawfully of lawful age, sound body, blah, 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 etc., voluntarily relating to the facts stated below, blah, blah, blah. Anyway, you can read this, and it basically lays out everything we stated above, that we were misled, deceived, induced to sign by false representations of mortgage investor company and whoever else, the preparer of the deed, and whereas fraud vitiates, I think I said that word correctly, all contracts and instruments, even judgments, the security deed number whatever is now null and void and therefore, based on the foregoing, I hereby exercise my right to rescind my signature from the security deed, to cancel and to render null and void all transactions arising therefrom, that would indicate in any manner whatsoever that I was ever subject to, liable for a debt owed arising out of such transaction. And you would take this with an acknowledgement. Now, this was the old way when I was just learning this stuff. You put the acknowledgement at the bottom of the document. You can still do that, but the proper way to do this is you would finish this rescission of signature, right? You would go to a notary. You would execute, you would sign the instrument in front of the notary, right? And attach it to your mortgage deed. And the notary would put a certificate of acknowledgement on top of this instrument right here. You understand? So, and if you want to get a copy of a notary certificate of acknowledgement, click the template quiet title action that follows this administrative procedure lesson, and you'll see a notary certificate of acknowledgement there. Or you can even Google it, because when we first were talking about acknowledging deeds, and this is the same concept, right? You can Google, you can YouTube Rob Ryder acknowledge the deed. This is the same thing you're doing with the rescission of signature. You're rescinding the signature, you're getting the notary's acknowledgement on it, which is going to absolutely be necessary in order for you to take this rescission of signature down to the county recorder's office and record it in the same county recorder's office where they record your property records. The same place where that mortgage deed is recorded is the same place you record the rescission of signature to cancel and nullify that instrument. After that, we want to pursue a quiet title action, because now that remember, we were the grantors, there's no other signature on that mortgage deed than ours. So the same way that we didn't have to ask any authority, we didn't have to go to any judge before we executed that instrument, is the same authority we have to rescind our signature from the instrument. But after we do that, we still have to deal with the assignment instrument from MERS, because usually the servicer is operating on behalf, allegedly on behalf of the creditor who never gave us a loan. So the purpose of the quiet title action will be to remove and clear all encumbrances on the house. Particularly, we'll be naming MERS as a defendant in the quiet title action so that we can call the assignment instrument before the court to have it canceled, because it throws a cloud on our title. Notice how we're not going to bring in the mortgage contract into the quiet title action, because we didn't need the court to rescind our signature on it. That's something that we had the right to do. But the assignment that arises therefrom does not have our signature on it. We can't rescind our signature off of it, but we can call for it to be canceled because it casts a cloud on our superior title in the quiet title action. We're going to learn a bit more about that in the next video. So thank you for watching. Visit www.thctrust.org, log in, create a free account. There's several free resources, but I encourage you to join the premium subscription group so you can have access to this template as well as other administrative procedures with the notary certificates and the certificates of default and everything else, as well as a few of the template lawsuits that we filed, including an FDCPA violation against a lender and the quiet title action. Thank you for watching. Peace. Anyone who's ever filed a lawsuit against these servicers, mortgage companies, and the attorneys that represent them, if you filed any lawsuit against them, you're gonna you know that the first thing that they do is they avoid answering, responding, or saying anything. They try to avoid discovery. They always try to get your case dismissed based on a technicality. In a federal court, they like 12b6, failure to state a claim. And really what they're doing on one part is they're exploiting the fact that you don't understand legalese and that you don't understand court procedure and things like that. So they're using that, and they understand that they can't justify that the actions of the bank, especially when it starts dealing with, you know, any of the robo signing or any of the false representations, you know, the deception and all the different elements of fraud that go throughout the entire mortgage. You know, them selling the note, splitting the note from the contract and still making you liable on it after they were paid on it. The fact that they never gave you a loan. They know that they can't answer to these things, and this is really the reason why they go through so much headache to get your case dismissed without answering or stating anything on the record. Well, the quiet title action changes the game in that regard, because the quiet title action, they can't just remain silent, and they can't dismiss the case. The quiet title action requires them to come in and state positively with the proper claim under penalty of perjury and a deed. They have to qualify their interest in the quiet title action as well as in the property. And if they can't do it, then they're going to lose by default. If they can't do it, then the summary judgment comes down that cancels all liens and encumbrances on the petitioner's land. And that's the ordinary due process of a quiet title action. You didn't even ask for anything yet. This is just what it's supposed to do by default. Now, of course, there's going to be specific things that you ask for, like the canceling of any instrument that casts a cloud on your title. But the point I'm making is this. And remember, before we talked about all these are courts of admiralty. This is an admiralty action in rem. Remember, I said there's two types: actions in personam, when they're making commercial claims against the name to make money, but then there's actions in rem. You're now filing an action in rem against the land. So this deals with your ownership rights to the land. So you're filing. So the defendant in the quiet title action is going to be the real property, or the land located at whatever address, and then there's going to be a legal description. So let's go to the Black's Law Dictionary definition of a quiet title action. All right, an action to quiet title. One in which the plaintiff asserts his own estate and declares generally that defendant claims some estate in the land without defining it, and avers that the claim is without foundation, and calls on the defendant to set forth the nature of his claim so that it may be determined by decree. So the point, what I want you to pay close attention to, is this is the normal flow. This is what a quiet title action is for. First, note that it says it's an action in which the plaintiff asserts his own estate. We'll start right there. In which the plaintiff asserts his own estate. So this means, this is why it's proper for the executor of the John Alex Doe estate, right? Or the trustee, the representative of the John Alex Doe Foreign Sitage Trust, Operational Trust, holding the property for the estate. It's proper for him to declare, for him to assert his own interest in the estate. And when I say his own, he's operating as an agent. So as the executor, he's asserting his own right in the estate. Right? Not really his own right, but the right of the estate. Notice they say his own estate. So what that means is you have to be the outright owner. You have to own it in order to bring this action. Only an owner can bring the quiet title action, because the nature of the action is to remove all liens and encumbrances that threaten your right to own the property. So what's important to note is you have, and you'll see it it'll be written in other ways too, but you have to bring your grant deed or your warranty deed. That is the foundational basis of ownership, and that must be in your quiet title action. And when you read your grant deed and warranty deed, that is the only deed that's going to say that you own the property in fee. That's F-E-E, right? And it's called a grant deed or a warranty deed depending on where you are at in the United States of America. Now, so that was the first part. And the second part, and And the plaintiff declares generally that the defendant claims some estate in the land without defining it, and avers that the claim is without foundation, and calls on the defendant to set forth the nature of his claim so that it may be determined by decree. So you're basically saying that some defendant, in this case it would be your servicer, is claiming some type of interest or some type of right in the land but doesn't define it. This is similar to saying when you ask your servicer to provide proof of claim, or you ask them to provide a statement of account, or you ask them to provide the documentation in the QWR, and they don't prove or respond to anything, but they continue to either advertise or threaten to take some type of action to foreclose on your property, right? And you're the owner because you have a warranty deed or a grant deed, and they don't have any deed at all. A lot of times these servicers, they don't have any deed. There's something for you to check to see if they even have a deed in the record, because if nobody answers your quiet title action, the summary judgment is supposed to move all liens and encumbrances from your property. But one of the gotchas, at least not for us, but for the servicer, is you can't even qualify an interest in a quiet title action unless you first have some form of a contract or a deed. But you have to have a deed. You have to have some type of instrument upon which your claim is based, right? So, again, it says that the plaintiff declares generally that the defendant claims some estate in the land, just like a servicer flexing to foreclose, without defining it, without responding to any of our inquiries, and avers that the claim is without foundation, and calls on the defendant to set forth the nature of his claim so that it may be determined by decree. And this hasn't changed. This is what quiet title does today. Let's read just a little bit more of this. It differs from a suit to remove a cloud in that the plaintiff therein declares on his own title, which we discussed, your warranty deed, and also avers the source and nature of the defendant's claim. And then it tells you a step further here. Points out its defects and prays that it may be declared void as a cloud on the plaintiff's estate. Then they give you another case law. So you go a step further in saying that the defendant's claim is invalid. You point out the defects, and you pray, or what you're asking for is that the court declare the defendant's instrument void as a cloud on the plaintiff's estate. So in our quiet title action, what you notice is first we did an administrative procedure, which basically gave them notice and acquired their consent and agreement that we was going to exercise the right that we already had on our own to rescind our signature from the mortgage contract. So it wouldn't be in our best interest. Actually, it would be counterproductive, and I sure wouldn't do it if I were you, for us to bring a mortgage deed where we're the only authorized signer on it in the first place into a quiet title action, asking the court to cancel it out. We're giving them too much authority. We're making a problem where there previously was no problem. Now, the servicer, the one who's trying to foreclose, typically has a service agreement, supposedly, but there has to be evidence of an assignment. Usually that's a record from MERS. Usually they send it to you when you send them a QWR, or if they ever send you a package about your mortgage, or if you ever got a sufficient discovery in court. You want to find that assignment document, because remember, you point out the defects in the defendant's instrument, and it preys upon the court to declare that instrument void as a cloud on the plaintiff's estate. You want the court to, where did it say when it came down here? Basically, you're asking the court to cancel it out. So we want to find that MERS assignment document, which is the alleged contract for the servicer that puts a cloud on the title. But even that contract is not a bona fide claim. It's not enough for them to qualify their interest in a quiet title action. But for the sake of having to ask the court for a remedy, we're asking them to cancel that MERS assignment instrument. Now, the fact that that MERS assignment instrument is already void because it arises out of a mortgage contract that's already been rescinded has not really been brought into this quiet title action, right? That's our administrative procedure. We already have that proven on the record, and we will use it if we have to further prove that the defendant's claim to the title is defective. But unless we have to prove that, then we're not even going to bring that. But it's backup. We're ready. But the problem is, I don't think in many of the cases your defendant is not going to respond because they don't have a deed in the first place, and you can't really assert a claim in an estate without some form of deed in a quiet title action. So let's go back to our website here that we found, and let's read a little bit more of what these attorneys have to say about a quiet title action, what they prepared. Let's see, here we go. An equitable quiet title, okay, here we go. In an equitable quiet title action, a court may cause to be delivered up and cancel any instrument which casts a cloud over the complainant's title. Then they gave you this statute. Every time you file a cause of action, you have to give every time you file a lawsuit, is what I meant to say, you have to give the court something that shows it that it has the authority to grant you the relief that you're asking for, right? So that's why this statute here is important. If you're not in Georgia, you want to Google quiet title action in your state and find a similar statute. In this one, it says a court may cause to be delivered up and cancel any instrument which casts a cloud over the complainant's title. So we have to be asking the court for a particular remedy, right? In the quiet title action that we prepared at thctrust.org, because most people are dealing with servicers, we ask the court to cancel the assignment instrument that comes from MERS to your servicer. And again, that instrument is already not valid because the mortgage contract from which it arises out of has already been rescinded. But that is all of those facts that we already have on the record is really not a part of the nature of the quiet title action unless this defendant servicer comes in and challenges our title and asserts their claim based off of whatever, right? So I'm just saying we have all these records, but we're really, as the Law Dictionary explained, we're asserting our estate in the land, our own estate in the land. So we're not talking, our primary focus is, hey, I have the superior title. If somebody else has a claim, then they need to make the claim. Oh, by the way, let me point out that in a quiet title action, in which I don't know why I didn't really see it in the legal the Black's Law Dictionary, but when you Google and look it up, you're going to see that your quiet title action is filed against the entire world. So a lot of times, although you have to point out a defendant that may have a defective claim in the title, you're also going to serve the entire world. So it may require you to give notice by publication in the newspaper, because the act to quiet the title removes all liens and encumbrances from the owner's title. And that's why they say quiet, right? Because you're quieting all claims. You're just like, speak now or forever hold your peace. And now they're in silence, so you're quieting them. Okay, so this makes sense. Let's read a couple other things. This is important. It says, generally, a party must be in possession of the property in order to assert an equitable claim to quiet title. Most of you guys dealing with some type of foreclosure situation are in possession of the property. In addition, a party must assert either current record title or current prescriptive title. So that means you have to either have a grant deed or warranty deed or some other prescriptive title. Let's say a prescriptive title may be some form of, I believe that's a title that's granted by the court because you've been in possession of the property for so long. That, like a quit claim deed, maybe that would be a quit claim deed. I don't know. Quote me on it. Do your further research. Let's see what else. It doesn't say it in here, but when you go check out other sites, it makes it pretty clear that in order to file a quiet title action, you have to be claiming ownership. This is what we'll do, as a matter of fact. This is the last thing I'll do because this is important. This is important with any type of legal action that you're going to file. elements. I don't know if you can see what I'm typing here, but I'm typing elements of quiet title action. Every cause of action that you will file in court has certain elements that must be present in order to have a valid cause of action. Now, those elements are usually defined in law dictionaries and law journals, and they're well known. So there's usually between 3 and 6 elements. I'm looking right here at this thing that I Googled, and they say 8 elements of quiet title action. I would have to question that because rarely do I ever find some action that has as many as 8 elements. These probably could be condensed. But let's see. Let's click quiet title, legal definition of quiet title action. A lot of times they'll show you the elements. Okay, this is something interesting. I'm just reading. I don't think you guys can see it, so I'm going to have to just read it. It says the general rule in a quiet title action is the plaintiff may succeed only on the strength of his own claim to the real estate and not on the weakness of the respondent's claim. That is powerful. Do you know what that means? That means even if you can't necessarily prove the defectiveness of the defendant's claim, because they like to wiggle and get out of things so well without saying anything, they try to avoid your administrative process or whatever. The rule in quiet title action is that you may succeed simply on your claim, which is your warranty deed or your grant deed, because that's your claim itself. That record right there is evidence that you own the property in fee. So the strength is on your own claim and not necessarily on the defectiveness of the defendant's claim. I'm just trying to give you an idea of the flow and the way that the quiet title action works, so why you may want to look into it. The thing that you have to remember is the defendant, if he wants to assert a claim, he has to have a deed, and not only that, he has to have certain elements to prove his claim. He has to have a contract. He can't produce a contract. He has to even prove that he has any type of right or interest that attaches to the property. He can't do that because he doesn't have a contract, and he's definitely not going to allege any facts under penalty of perjury. Right? We already know why they won't do that. We kind of discussed that. But yeah, I wanted to show the elements of the quiet title action. Sometimes they're pointed out like 1, 2, 3, 4. Here we have, under the common law, a plaintiff must be in possession of the property to bring a quiet title action. So you see that? They tell you on this site that under the common law, you must be in possession of the property. So there you have it. That would be one of the elements. But many states do not require actual possession by the plaintiff. Under the common law, it does, but under the many statutory versions of a quiet title action, it's not required. Okay, this might be it right here. Michigan Code Revised, whatever, and this specify the information which must be contained in the complaint, including a legal description. So that's one. It describes the property, the interest of the plaintiff, which would be your grant deed or your warranty deed. So here's the elements. So you can see them here if you look closely. It's saying you have to have a legal description, including a legal description that describes the property with reasonable certainty. So that's why you're going to say the land located at, and you're going to have a legal description as one of the exhibits in your quiet title action. The interest of the plaintiff, that's what your warranty deed is. It's going to assert that you are the grantee, someone else was the grantor, and you received the deed in fee. You have to put your acknowledgement on that grant deed. If you don't know what that is, make sure you write this down. Once you finish this video, YouTube Rob Ryder acknowledge the deed, and that's how you will complete this element, which is asserting your interest, and the facts establishing the superiority of the plaintiff's claim. So then you will put a brief statement of why your claim is superior to, let's say, the defective claim of the defendant. That'll be your statement of facts, but you want to keep brief and to the point. You don't want to go all into your administrative procedure. You just want to state positively, because remember, as we read earlier, the survival of your claim is going to be based on your superior claim and not the defectiveness of the defendant's adverse claim. And then a statement of the origin of the title in which the pleader relies, including any written evidence, etc. So make sure you include all of these things in your pleading, and a lot of this is going to be covered by simply including an acknowledged copy of your warranty deed or your grant deed in the record. Let's see. I'm going to kind of leave this part to that. Stop recording. All right. So to recap, basically we started out talking about the administrative procedure where we wanted to establish for the record that the original lender did not give us a loan. He couldn't have legally given us a loan, but so that we can be sure we did our due process, we presented him with the facts via notary presentment, and we gave him a certain amount of time to provide assurance or show cause or prove that to the contrary they did give us a loan or provide consideration, and we knew that they wouldn't do that, and when we defaulted, we certified the facts for the record that they did not give us a loan and that the entire mortgage contract was executed under the influence of false representations, deception, and omissions and intentional misrepresentations to get you to pledge and sign over a security interest in your property and your note. So we established those facts via our administrative procedure, and we further gave notice of the other party to either respond or consent by their silence to our assertion of our right to rescind our signature from the mortgage contract. We did all that via an administrative procedure. When they defaulted and we got the certificate of non-response and the notary's witness of their default, we went on and rescinded our signature from the contract. Then we took that rescission of signature, attached it to the mortgage deed, and we recorded it in the county so it would be on the record. Now, on the contrary, we still have that faulty service assignment, and that we still have that out there, and this puts a cloud over the title that we own in fee. So for that, we filed a quiet title action, which we just discussed. And as you see here, this is a template. It may or may not be the best. This is what I came up with based on my research, and this is available for the members of thctrust.org, so you can grab it and make it personal. Notice how I did this. You may not do it. You may or may not do it like this. It depends on your level of understanding and competence. There's a lot of advanced stuff going on here because I understand about I have my foreign situs trust set up, and I am established as the executor for the estate of Tex Masson, and I have my articles of association and my declaration of trust and all these things that I'm not going to say that they're necessary, but these things I already have them in place. That's why my caption is written like this. I probably should I could put non-domestic without the United States and things like that, but I'm going to just keep it like this. I'm going to just, I'm already operating a trust over here, so I have all those protections. So I'm just going to bring it into the court of equity like this. This is the caption. Remember I said this is in rem. Remember, this is, in personam is claims against persons. And this is actually a person right here, all the world, because it's a statutory person created by the Georgia codes, so to speak. But this is the property, the real property located at 806 Oak Lane, whatever, right? But there's going to be a legal description inside the actual lawsuit. But notice it says defendant in rem, because when you're proceeding against a thing, it's said to be in rem, right? You remember, and it's the land, that's the real defendant. So you're asserting your estate as the executor, right, in that land, saying that this other defendant, which is going to be all the world, and it may be MERS, it may be, bank of whatever. It just depends on, you got to read the statutory requirements of quiet titling in your state. We're covering 80% of it, but you may have to tweak it if you use our template. So here's the first part of it. The petitioner Tex Lee Masson by its executor, properly known as Masson Lee Tex. Notice I use that last, first, middle, which is the proper name. Jonah Bay kind of brought that to light. That's the creditor's name. That's the executor for the estate. He's out there under the common law, but he's in this trust vessel bringing this claim. Regarding the real property located at 806 Ivy Lane described in Exhibit A. Exhibit A would be a legal description of the property. I, Mason Tex Lee, declare under penalty of perjury that the facts stated below are true, correct, and complete to the best of my knowledge. I set it up like an affidavit. The land is parcel to the estate of Tex Lee of the family of Son, who owns it in fee, who owns the land in fee, simple, absolute, as evidenced by the attached Exhibit B. That's going to be your warranty deed or your grant deed. I'm not going to go through this whole thing. This template is available for the premium subscription group at thctrust.org. Okay, so that concludes this lecture. If you would like the documents that go along with this lecture, simply go to the website, create a new account if you don't have one. If you do have an account, just log on in. As such, and once you log into the website, you should see all the menus appear on the right side. Scroll on down the website until you see Mortgages and Foreclosures. Click this menu right here, and the information will be under here. As you see right here, there's one article that's the Uniform Residential Mortgage Satisfaction Act. By the time you get here, there will be another article right here, and this will conclude the administrative procedure along with the quiet title action templates. Thank you for watching, and again, since you're here, if you want to join the premium membership group, go right up here where you see this that says membership. You can click on that, and then simply, I can't scroll any further because how my screen is. Let's see if I can scroll further. But anyways, there's a button down here. You go to this page right here, you keep scrolling down, and right off the screen here that you can't see, there's a button. You click that button and you can set up your PayPal $24 per month subscription. Thank you. Peace.